Hello, and welcome everybody. Thank you so much for joining us for our latest webinar, Child Custody 101, an introduction to New Jersey child custody. Of course, our disclaimer, please know this presentation contains general information and does not constitute legal advice. Be sure to direct specific questions about your own situation to an attorney. So what we're going to talk about today in Child Custody 101, firstly, the best interests of the child standard, legal custody versus physical custody, New Jersey court procedures, modifying your custody orders, and enforcing child custody orders, of course, and give you resources if you have any questions or need additional help. So what is the best interests of the child standard? Well, child custody orders are based on the best interests of the children as determined by all relevant factors. The law is gender neutral, meaning it does not favor moms over dads, and parents have equal rights and responsibilities to their children. Determining appropriate custody requires consideration of all facts and, as I said earlier, is gender neutral. No form of custody is given automatic preference, but frequent and continuing contact with both parents is presumed to be in the child's best interests. So how do courts decide custody? Well, they can be done either through agreements between the parents or by court order if the parents cannot agree. Now, agreements between parents. Courts always prefer parents to make their own agreements about how to share parental responsibilities and parenting time. Parents can and should work together to develop a schedule that fits the needs of everyone in the new restructured family. To be upheld in court, though, a parenting agreement must comply with the best interests of the child. That's always the overarching and underlying standard that all courts in New Jersey use. If parents can't agree on a parenting plan that meets the child's best interest, then the court will order a plan. The statute that controls custody in New Jersey, you see it there, NJSA 9:2-4. Whether the parents reach agreement or the court orders a plan, the factors in the New Jersey child support statute must be considered in determining the best interest of the child. There's that phrase again. The factors listed in the statute are not exclusive. Courts should consider all relevant factors. So what are some of the statutory factors? Well, first, safety. The court should consider any history of domestic violence, the safety of the child and either parent from physical abuse from the other parent, and the parent's fitness. Court should also consider the emotional needs of the children. What about the interaction and the relationship of the child with the parents and the siblings too? What about the status quo? Well, the court should consider the extent and quality of the time spent with the child prior to or subsequent to the separation. Practical concerns, of course, the child's needs, the stability of the home environment offered, the quality and continuity of the child's education, the geographical proximity of the parents' homes, each parent's employment responsibilities, and the age and number of the children. What about the preference of the child? Well, the preference of a child who is of sufficient age and capacity to reason so as to form an intelligent decision will be considered by the court. The court can interview a child with respect to this, but done in chambers, not in open court. Another factor considered is the ability to co-parent effectively. The parent's ability to agree, communicate, and cooperate in matters relating to the child is really important, as is the parent's willingness to accept custody and any history of unwillingness to allow parenting time not based on substantiated abuse. The court will look at this and will weigh this strongly. So what is the difference between legal custody and physical custody here in New Jersey? Well, legal custody governs a parent's authority to participate in big decisions in the child's life, such as major medical decisions, education, and general welfare. It includes schooling, religious upbringing, medical treatment beyond routine or emergency care. Legal custody can be sole or joint, but joint legal custody is pretty much the default in New Jersey unless one parent is wholly absent or abusive. Joint legal custody usually means parents make all the decisions together, but in some cases, one parent will have the authority over certain aspects and the other will have authority over other aspects. Physical custody. Now, physical custody governs which parent a child lives with. One parent can have sole physical custody, or parents can share physical custody. Sole physical custody usually allows for liberal visitation or parenting time by the other parent. Joint physical custody is considered shared custody when it approaches a 50-50 split, and there's also full sharing of parental responsibilities. This is really significant in relocation or move-away cases, which we'll discuss later on. What are some common child custody arrangements? Joint legal custody, which is, again, shared decision-making with one primary residential parent. This is the most common. Shared legal and physical, equal or nearby equal parenting time with equal responsibilities. Also common, but requires above-average co-parenting skills. And sole legal and physical custody. This is unusual unless one parent is absent or abusive. You rarely see a court order sole legal and physical custody. So joint legal custody with a parent of primary residence. Parents here in this situation share decision-making authority for children's health, education, and general welfare, while the parent a child is with at any given time makes day-to-day decisions in the child's best interest and notifies the other parent as appropriate. So child gets sick, has to go to the emergency room. Obviously, in that moment, parent makes the decision but notifies the other parent. The child usually resides with one parent the majority of the time, while the other parent has a more traditional parenting time or visitation schedule. Now, even when the physical custody is approaching 50-50, it will not be considered shared physical and legal custody unless the parents also share parenting responsibilities 50-50. Shared legal and physical custody, it generally refers to a parenting arrangement where children spend equal or nearly equal time with each parent and parents share day-to-day parental responsibilities equally. This is less common than the scenario we just talked about, the joint custody with a primary parent, because it really requires a high degree of communication and collaboration. Scheduling options include alternating weeks or splitting the weeks, sometimes alternating one day and night of each week to equalize the time. No bright line distinguishes true shared custody from joint legal custody with a primary parent, but the distinction can be important when figuring out child support, as well as in a move away or relocation case. And lastly, sole legal and physical custody. Again, this is pretty rare. The residential custodial parent is solely responsible for all major decisions, including health and education and welfare. Some parents just agree to this, but it is commonly comes about after a judge has determined that one parent is either completely absent or unfit due to a history of abuse or neglect or drug addiction or some similar issue. In the majority of such cases like this, the non-custodial parent will still have visitation with the child, but visitation may be supervised or restricted to ensure the child's safety. So what is parenting time? Well, in New Jersey, child visitation is often called parenting time because a parent is really never a visitor. Are there restrictions on parenting time? Well, courts may impose temporary safeguards such as requiring a third party to supervise the parenting time until that parent has satisfied certain requirements, completing a drug rehab, for example. In the most extreme situations, a parent may be prohibited from exercising parenting time entirely. An award to one parent of sole custody is not the same thing as termination of the other parent's rights. This is important. The other parent, even if one parent has sole custody, may still be obligated to pay child support. The parent also retains the right to return to court at a later time and request a modification of the custody and visitation order if there are restrictions. Now, losing parental rights. In very extreme cases of imminent risk of physical or psychological harm to a child due to parental abuse or abandonment, New Jersey DCP&P may take temporary out-of-home placement for a child's safety. A temporary custody arrangement ordinarily becomes a permanent one only if parental rights are terminated through a court process. Now, DCP&P tries to provide parents with support, and termination of parental rights really is a last resort. So let's now talk about the New Jersey court procedures in child custody cases here in the Garden State. The court must have, first and foremost, jurisdiction over the child. Jurisdiction is based on where the child lives for at least 6 consecutive months. Once a state exercises jurisdiction, it normally keeps jurisdiction even if the child moves away. Now, a state can have jurisdiction over an absent child who resided in the state within the past 6 months if a parent or guardian continues to live in the state. Frequent moves in and out of the state can complicate jurisdictional issues. You want to avoid allowing a child to live with another parent out of state or country without a custody order in place. You really could find yourself bound by out-of-state custody orders if one doesn't already exist here in New Jersey. So be careful with that. Now, what about temporary motions? Do you need immediate help from the court? Well, you can file for pendente lite motion for temporary relief at any time during a divorce case if one is already pending. Temporary parenting orders may be necessary at the start of a divorce to protect the children and prevent one parent from making unilateral decisions. Temporary child custody orders are generally based on maintaining the status quo that existed before the start of any legal action. The court will absolutely require you to settle your parenting issues. There could be court-ordered parenting classes. You and your ex could propose a parenting schedule to the other and try to negotiate that, or there could be court-ordered mediation. So procedures for parenting time disputes in the New Jersey Family Court. The court sends most cases involving custody or parenting time issues to court-mandated parenting mediation. There, each parent proposes a parenting plan, and if the parents can't agree in mediation, then the case is put on a priority track, meaning that it should be heard by the court sooner rather than later. Things to include in a parenting plan. Parenting plans become part of a court order, so they have to be followed. And at a minimum, your plan should include where the child is going to live primarily, describing legal custody. Is it joint custody? Is it sole custody? It should include a specific time sharing schedule. Who has the child when? And it should also include provisions for holidays, birthdays, and vacations and breaks from school. Additional items to consider including in a parenting plan are access to medical records, report cards, teachers, first rights of babysitting, who gets to take the child if the other parent needs to leave for any reason, responsibility for specific expenses and for sharing unanticipated expenses, responsibility for transportation of children to and from parenting time or to and from shared custodial time, and for transportation costs as well. Designating a parent to take off work if a child is sick. Means of addressing potential schedule changes or modification of a plan as children get older. Agreement to attend mediation first before going to court, and any other agreements that you and your ex wish to include. Question: what if you can't resolve your parenting issues through negotiation or mediation? Well, the court may want an expert opinion. Custody investigations and evaluations can be done through the family division or through private custody evaluations. In the family division or through the court, a judge can order a social investigation or a best interest investigation of the child, and a report would be done and given to the judge. This may include a home inspection to make sure the home is appropriate. Could include a psychological, psychiatric, parental functioning assessment, or mental health evaluation if necessary. And the judge can also interview the child, but in chambers, not in open court. Private custody evaluations. Parents can jointly hire a mental health expert to conduct the investigation and prepare the report for the court, or parents can each hire their own expert. Whatever the case, child custody evaluators must be neutral and follow uniform standards regardless of who hires or pays for them. Using a neutral child specialist. Now, a licensed mental health professional with training in child development and family systems can review proposed parenting plans in light of the best interest of the children. Remember, that's the standard. You should choose someone with experience working with parenting issues common to family reorganization. Private custody mediation, which is an out-of-court alternative. Mediation can reduce conflict and decrease the stress on everyone in the family. It's confidential and can keep your family matters private and out of the public record, which the courtroom is a public record. Private mediation offers many additional potential benefits, including increased control over the process and the result. If you and your ex can come up with your plan on your own, why have a stranger, the judge, come up with a plan for you? Private mediation can be started prior to filing a court case, so you wouldn't even have to go through the procedures if the two of you can come to an agreement through mediation. Private custody mediation, it's also a process that protects children. Watching parents argue is absolutely hard on children and often makes them feel pressured to choose sides, which could absolutely cause emotional turmoil. Mediation helps parents preserve or improve upon the cooperative relationship essential to co-parenting, which really is the goal. Parents who reach agreements on parenting matters in mediation often learn valuable skills that can help them resolve future disagreements they may have. Even if serious parenting disagreements arise in the future, parents can often resolve them by going back to mediation. Post-judgment modifications or changes in New Jersey child custody orders. How are things changed once there already is a judgment regarding custody? What if things change in your life after final custody orders are entered? Well, child custody orders can be modified until children are emancipated, meaning they're deemed to be independent. They got married, they're over 23 years of age, they joined the military. All changes or modifications require a substantial change in circumstances before a judge will change an order. What has happened in your life that would constitute a substantial change in circumstances? Courts will expect parents to try to work things out through negotiation or mediation, as we talked about earlier, before going to court. So what is a substantial change? Some potential triggering events are an increase or decrease in parenting time, a change in the primary residential parent. So say one parent had residential custody, now it's another. A change from sole custody to joint custody or vice versa. Courts considering a request for a major change will require proof that the change is necessary to further the child's best interests. Move away cases. We talked a little bit about this earlier, but what happens if a parent of a minor child born in New Jersey gets a new job across the country and wants to relocate? Well, they can't relocate out of the state with the child without a court order or the consent of the other parent. Under former law, a parent wishing to move with the child needed to show that the move would benefit the child. But under the current law, a parent with sole or primary custody can move if the parent has a good faith reason for the move and the move will not be harmful to the child. What about joint custody in these types of move away or relocation cases? Well, joint legal custody is not sufficient to trigger a full review. If the parents have true shared custody, meaning an equal or nearly equal division of time along with equal division of responsibility, then the parent who wants to move must demonstrate that it would be in the child's best interest for the court to change custody and designate that parent as the primary custodial parent. So in other words, the court would actually end the shared custody arrangement and would make the moving parent the parent of primary residence. Now, only after that hurdle is crossed with good faith and lack of harm standard will that be applicable. So what is a good faith reason to move? Essentially, any reason that is genuine and not motivated by a desire to keep the child away from the other parent would be a good faith reason. An example, like we talked about earlier, a new job offer, a new spouse's job offer, an anticipated remarriage to a person who is pigeonholed to a different state, or perhaps being closer to extended family members. How does a parent show lack of harm to a child if they want to move? Well, they would demonstrate that educational and recreational opportunities for the child in the new state are at least as good as those in New Jersey. And they need to propose a reasonable visitation plan that will allow continuing and frequent contact between the child and the non-custodial parent. The proposed new plan must allow the child to maintain a close relationship with the non-custodial parent and must specify when the child and the non-custodial parent will spend time together. Acceptable alternative parenting plans. The child will typically be with the non-custodial parent during school holidays such as winter and spring break and for the majority of the summer break. The plan must specify a reasonable method of transportation for the child and allocate the cost of such transportation appropriately between both parents. The plan must also specify additional methods of contact, such as unlimited telephone calls, email, text messaging, and/or Skype. The plan must actually work for the non-custodial parent. So opposing a move-away case. If you don't want the child to move out of state, you must demonstrate shared custody if it exists, or demonstrate a lack of good faith for the move or harm to your child. In either case, focus on the closeness of your relationship with your child and show how the child would be adversely affected by your inability to fulfill current roles at a geographical distance. Let's talk for a minute about Bowers v. Lewis. This is the case in New Jersey that the court looks at when determining if moving out of state is in good faith and there would be a lack of harm to the child. So the factors in Bowers that the court looks at are: 1, the reason for the move, the reason for the opposition to the move, any past interactions between the parents that bear upon reasons for or against the move, whether the move will afford the child with comparable health, education, and leisure opportunities, any special needs or talents of a child requiring accommodations, and whether such accommodation exists in the new state, the availability of a satisfactory visitation and communication arrangement that will allow a full and continuous relationship between the child and the non-custodial parent, and the likelihood that the custodial parent will continue to foster a relationship between the child and the non-custodial parent, the effect of the move on extended family relationships, the preferences of a child if the child is of sufficient age, whether the child is about to enter their senior year of high school, whether the non-custodial parent has the ability to relocate as well, and any other factor relevant to the best interests of the child. So how do we enforce child custody orders and agreements in New Jersey? Well, parents have a legal duty to comply with court-ordered parenting plans. This duty generally includes encouraging a child to spend time with the other parent. Parents must also refrain from making negative comments about the other parent to the child. Interference with custody. Well, interference with custody or visitation includes subtle behavior like blocking telephone or email contact or consistently scheduling a child's appointments and activities during scheduled parenting time. Only in severe cases should you consider court action. Usually the better approach is attempting to work things out with the other parent on your own, maybe through mediation. If your child's other parent is consistently violating custody or parenting time orders, consider bringing both a motion to enforce litigants' rights and a motion requesting a change in parenting arrangements. Interfering with court-ordered parenting time can be a crime in New Jersey. A parent who conceals a child from the other parent for the purpose of interfering with custody or visitation may have to actually serve jail time. What are the penalties that the court can impose for interference? Well, New Jersey Court Rule 5:3-7 says, in cases involving failure to comply with parenting time orders, New Jersey family law judges can order whatever remedies are justified under the circumstances. So that's pretty broad leeway the courts have. A court may order temporary or permanent changes in the parenting plan, including some or all of the following: compensatory parenting time for the parent who lost the time, changes in transportation arrangements for the visitation, changes in the children's pickup or drop-off location, or even a change in the primary residential parent. A court can also order the interfering parent to pay the other parent's attorney's fees and court costs, attend parenting classes or counseling, pay for counseling for the children or for the other parent, pay any costs resulting from non-compliance with the court order, participate in community service, or even comply with a warrant for arrest. What are some defenses to interference with custody? Well, there could be imminent danger to you or your child. If that's true, you really should contact DCP&P, formerly known as DYFS, at 1-855-INFO-DCF, the local police and the district attorney's office in your child's county of primary residence, and find out the child's location as soon as possible, usually within 24 hours. If there's domestic violence, bring a custody action in an appropriate court as soon as reasonably possible. Contact an attorney or DYFS, DCP&P immediately to ensure that you are complying with the law. Non-receipt of timely child support payments is not a defense to holding back custody. Do you have any other questions? Well, please feel free at any time to give us a call at 888-888-0919 or shoot us an email at info@weinbergerlawgroup.com. Or you can certainly ask your child custody question online. Of course, if you feel as though you want to speak to an attorney about your specific child custody or parenting time issue, give us a buzz at 888-888-0919 and schedule your free legal confidential consultation to discuss your specific New Jersey child custody matter. Of course, visit our website. We have more information there about child custody and all types of family law issues at www.wlg.com. Or again, shoot us an email at the email address there, info@weinbergerlawgroup.com. Thanks again so much for being with us. We hope you learned something new today. And if you have any other suggestions about what you'd like to see covered on future webinars, give us a shout out. We'd love to hear from you. Thanks.